morning, Your Honor.
Thank you. Good morning.
Christina Stifler and Alan Mizrahi on behalf of the state. We're here on the case of Mario Fernandez, number 1 on the court's calendar.
Good morning, Your Honor.
Good morning.
My name is Jesse Dreiser, and I represent Mario Fernandez. I'm here along with Ms. Day. Mr. Hill had a federal status conference, which he's doing remotely, I believe, in the jury room, and hopefully he'll be out here in a little bit.
Okay. All right. If you would, today is the court's operating final pretrial, and so I may be addressing your client. If Mr. Fernandez, if you would please raise your right hand to be sworn in.
Sir, do you solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
All right, thank you. All right, you can be seated. I'm going to talk to the lawyers for a little while, and I'm going to confirm some things with you, okay? All right, so I appreciate both sides. I've been looking at the diligent work that you all have been doing, even as of late, and so I want to kind of take up one thing at a time, which is first starting with, yes. Okay. Mr. Smith, he said I'm muted.
You're muted on at the Zoom.
Okay. All right. And then so I want to take up first one thing at a time. So we are going on the indictment that was initially, it looks like it was filed August 17, 2023. Is that correct?
It is, Your Honor, and this morning the state has filed a statement regarding the indictment. I provided a copy to Mr. Dreiser yesterday. And we've been in discussions regarding this. The state will be proceeding on counts 1 and 3 of the indictment.
Okay.
Which is the homicide and the solicitation. I provided a copy of that statement to Your Honor and have filed with Mr. Hathaway.
So for purposes of the trial, and this is known by the defense, I'm assuming.
It's been talked about for probably 10 days. I got official notice yesterday.
Okay. And so for preparation, instead of filing a superseding document, what I would ask is that the state prepare what we would call kind of a dummy indictment.
Yes.
With renumbering just for record purposes. So 1 and 3 for all of our purposes. So 1 for the official record will remain 1. 3 will become count 2.
You're referring to what you'll read to the
Correct.
jury? Yes, ma'am, I'll have that done.
All right. And then so I guess the state abandoning 2 and 4?
Yes, Your Honor.
Which is the conspiracy and the child abuse.
Okay. All right. So I believe you can interlineate these documents if you want, and then for just so it looks clean, if you could prepare one for me and one for the defense,
Sure.
But you want to interlineate the document that's filed in the court record?
I can do that. Mr. Hathaway and I will confer, but I don't.
Go through this with him.
I assume this statement regarding the indictment is filed should sufficiently take care of it.
All right.
It is a joint indictment, so my concern is making any interlineation into Mr. Fernandez's case that does not apply to Ms. Gardner's case. They're on the same indictment.
Okay. So you're going to prepare another document?
Yes, Your Honor.
All right.
And I don't know if she said this, but I do think you would want to know, I'm sorry if you did, their indictment is not being modified in the same way in which ours is. So.
Right.
Correct.
Right. But we're going to have a clean document so that I'm not
I
reading.
agree with that. I just
Okay.
wanted you to know that that it wasn't the same, meaning.
So what I've done for myself is I've highlighted his name. I was going to only read that portion of it, but it would be nicer for me if I could just read.
Absolutely. I'll make one as if that is the way that Your Honor would read it to the jury at jury selection and trial. I'll provide a copy to Mr. Dreiser for his approval and then forward it to Your Honor.
Okay. And then I did get I don't know that it's filed, though, a statement of facts.
We have agreed on a statement of facts.
It needs to be filed.
Yes, Your Honor.
And
Right, we can file that today, Your Honor.
Okay. And then, so,
oh, can I have one moment with the state?
yes.
Hold on.
Practice this.
Still,
I know, I'm working on it. Judge Kite. Okay, sorry.
Okay, so,
That'll get filed today.
okay, great. And then in looking at the order that I introduced, that I filed, the way that jury selection is going to go forward, phase one, which is scheduled to start on August 10th, I believe that the clerk's office may be prepared to bring up more than 50. Would you all be interested in that or no? You want just the 50 to work through for the morning? The question was posed to me that, if they had 70, if they had 100. I personally think 100 is too much to try to get through in the morning, especially, I'd rather we can hold over some for the afternoon and get to that point, but I want to have people waiting as little as possible.
No one does this more than you. I defer to you on what you think the timing of that procedure would take. You would know better than I would.
State's thought process, Your Honor, is that as long as the jurors are comfortable and are not sitting on hard benches in court during this process or sitting on the floor outside, I've had a case before,
Yeah.
too many people. So
Right.
I want to make sure the jurors are comfortable and they're in a position where they're not being inconvenienced. It doesn't matter to me if it's 50, 60, 70, as long as they're not being inconvenienced.
So this courtroom, I think, can comfortably seat, I think, up to 100. But our magic number for questioning purposes is 100. And so we could possibly, I want to have hard breaks, which will allow everyone to kind of keep the stamina of the trial, so noon lunch to 1 p.m. and if we're more regimented in that factor, but we'll know from the first group. My suggestion would be we keep to the 50, work through the 50, and if we're done a little bit earlier, okay, you can go to lunch earlier, then we bring another 50, and just be more pragmatic about it than bringing up way too many people and then working over. That would be my preference.
That's fine.
And how, that's fine, but how quickly, let's just say that the first 50 comes up and 5 people say they have a hardship for timing and calendaring purposes, and 5 people say they know something about the case and our line into room 2 is only 10, and the rest go, and they start filling out questionnaires, how quickly could we get another 50 people is, I guess, the question I'd want to know.
Well, they would be summoned for the afternoon, but then you would have, if, let's say we finish early, then you would have the time to kind of go over the questionnaires
Okay.
a little bit longer.
Sure. All right.
So it would just be, if we finished a little bit earlier, that would give y'all more time to work and not be kind of under the pressure of questioning more jurors. But I say we kind of stick to that process until we see that how hard or how easy it will be. And so let's say potentially we get the first 50, we're able to work through those individuals very quickly. You'll have a little bit more time as far as a break. We get the next 50, it's a little bit harder because, you know, it's really juror dependent. But the main thing is that we have the groups in here that it's already designated that you're going to have the group that's going to remain in here and then the group that's going to go into the side room where we discuss the hardships, and we can get through those hopefully very quickly. Are y'all interested in my chart for hardships? Do you want that?
Yes,
It's something I do. I'm going to keep my own, but I'm happy to share it with the parties.
that's fine.
Yeah, please.
Yes, ma'am.
Okay, so I developed it, I came up with it last time, and then it just allows notes to be kept, like who stays, who goes. All right, so I'll send that to you all.
And just, my recollection was, once we get 100, we'll bring back 100 that day for actual, traditional voir dire, except once whoever comes back out of that 100 will release X amount of people to only have 70. Is that everyone else's recollection?
No, I think we ended up with
We're going to have
a
100.
92.
What? We're going to have 100. Because once y'all get to the questioning, I mean, you don't have to question the remainder of the panel, but it would be nice if you're exhausting cause challenges, if you're, like, there are things that you can't anticipate, to have the jurors instead of trying to summon more. But my thought is Monday morning, 50. Monday afternoon, 50. And then I think that we should be able to get to the 100, definitely, hopefully by Tuesday. That's what I'm thinking. And then Wednesday afternoon is when you start your actual questioning of the jurors. So you all will have all that time to go over the questionnaires and do your work. And then we will start Wednesday afternoon with the actual selection process. And that's just in case. So if it's too hard, then we would still have Wednesday morning, another 50.
Yeah, and I would like the court to know it's probably going to be the defense's request that if it starts in the afternoon and the state goes, unless they are real quick, I don't think I'm going to want to go that afternoon, break mine up, and have a bunch of very tired people late in the day.
I understand.
Okay.
But they'll be fresh. That's the point of not starting in the morning.
I understand. It'll be dependent on our request.
So, I mean, I do still have, my thought for phase one is that I come out, I do my normal introduction of myself, of the staff, of the parties. That would allow for that kind of baseline questioning. Does anyone recognize anyone? I read the indictment, I read the statement of facts, and then I'm going to publish the trial schedule. I'm thinking this whole scenario would take, I'm thinking 20, 25 minutes, okay? And then I'm going to tell them that we're dividing ourselves, they're dividing themselves into two different groups. The group one is going to say that they want to be heard as it relates to they've heard something or they think they know something about this case. Group one will also be considered individuals that want to be heard related to hardships or difficulties with the trial schedule. Group one will also be individuals that believe that they know either myself, any staff, or any of that. I'm not taking any questions in a big group. Group two are those that believe none of those issues apply to them and they don't want to be heard, and therefore they're going to remain in the courtroom the questionnaires are going to be distributed to them, and they're going to complete the questionnaire. I'm going to tell them and read to them, what they are essentially swearing under oath that they are doing, because then they need to know the seriousness of it, because before I leave. And then once we divide out into two groups, I've already gotten with court administration that they're going to have sufficient number of bailiffs to help facilitate the line where whoever wants to be in during the questioning, will be excusing ourselves. The remainder, we will not be in session in here, but for collection of questionnaires after both sides agree that it is filled out properly, the clerk's office is going to scan and then send those out to the parties. And so depending on those numbers, we'll know how many to that our cutoff is. And then I was going to give them the report date of Wednesday afternoon, but if y'all want to start in the morning, I'm happy to do that. If we think that, we can always summon more jurors to get to the Wednesday morning. Would y'all rather have Wednesday morning report back date? Because I haven't set that for the jurors that have finished the questionnaire.
I think that we should start with a Wednesday report back date, but if we notice from the first 50 that we're seeing a lot of hardships and or media attention,
Just to be able to contact those individuals and move it.
we say it's tentatively Wednesday morning, but then, if we see that in the morning and the afternoon that it's going slower than we anticipated, then we can always bump it back to Wednesday afternoon. So I would tell the jury to make sure that we have a good phone number and that they check it and those kind of things. Or they call in. I don't know, they could do a voice recording like they do for jury selection where you call in and it says, you have to show up at Wednesday morning.
I don't know. From the clerk's office, do you know if that's available?
Your Honor, I know that they can update their message, but if it's not standard Monday jury selection, it's not that for this specific panel.
I think my preference is to stay with what your initial thought was, which is Wednesday afternoon. That'll give us the sufficient time that we need to go through the questionnaires and do the work that we need to do outside of the courthouse.
It's up to y'all. It doesn't matter to me.
We are in disagreement. I think that we should use the time. I don't want to rush things. I think the court's plan is great. I think that we should be able, in 2 days, to have 100 people. And I just can't imagine that we're going to have, I guess if we're doing 50 at a time, that's 100. That's out of 200 people that we're going to have half of the people be strict. Maybe I'm wrong.
And I agree with Al.
Even some of the people that have heard of the case are going to be able to sit.
Right.
This isn't a situation, there are obviously maybe some pieces of evidence that they learn about that they cannot sit. But if they're like, I heard something about a guy shot in Jack's Beach, it's not having any, fixed or definite opinions. I think those people are allowed to sit. So I think that on Monday, and if we go slow, perhaps leading into Tuesday, we should have the 100. So to come back Wednesday afternoon, I'm not sure that's necessary. But maybe I'm optimistic.
It's not his optimism that is objectionable to me. It's that I'm anticipating the work that we're going to do getting to the 100, and then the work that we need to do to sufficiently understand who these people are. That's the extra time that I'm seeking.
I'll do the Wednesday afternoon. You all can use the time to work on your trial, or we can even use the morning if you need. And let's say you've done your work, that if there are any hearings or anything at the last minute, we can come together prior to jury selection.
Yes, ma'am.
That should still allow us to finish Thursday.
100%.
Yeah.
And then you would have all of Friday.
Friday for me.
And, yeah. My jury selection is not taking an entire day, so
Okay.
I don't believe so. And I still, I don't know why, I'm not trying to push back, it's not that big a deal, but I really thought that we had, when Mr. Mizrahi and I were doing the math with the court, we really were comfortable with 70, and then
If you want to do 70, it's fine with me, but
you said, which was, I thought was really smart that I didn't think of, was yes, but when we get 70, there's a chance that when the 70 return, you'll get some illness, you'll get some, I saw the case on the news, you'll get some problems. So I thought you were saying, let's get 100. Let's get 100 to return, see who returns, right? And then that'll make sure that we actually have 70 sitting panel, a panel of actually 70 by bringing 100, and then we'll excuse the remaining 13 people or whatever.
So how about we leave it the way it is, 100?
It'll go
Okay,
faster.
but however, you all will know from the questionnaires whether there could be an issue and we can keep the 100 or not. Like, you don't know, there's a great unknown about like what people are going to put on their questionnaires. I think that was part of the conversation as well. So we get to the 100, everyone reports back. You all have done your work as far as the questionnaires are concerned. If there is concern that a number of these people may not be able to serve, I do want to get to at least a good solid 70, and maybe the 70 comes out of the 100, and we can say from the questionnaires, these are problems. We can also bring in people individually that may indicate issue on the questionnaire that is not right for the entire group. So I'm fine if y'all want to just question 70, but we're going to bring back the 100. So if you want to seat 70, is that agreeable with the state?
We can just, good.
Okay,
We can make
all
that
right.
decision that morning.
And then we'll see who comes back at 100.
Yeah, that makes
Right,
more sense.
and then after y'all have, because there's a great unknown. So,
You can have 30 come back and say, I can't do it.
correct.
70.
I definitely agree with the 100. We can come to a decision that morning. I think that makes more sense.
So, I mean, you all know,
Thank you.
that in jury selection, generally what happens is they go outside and they start talking to the bailiffs, and they start telling the bailiffs this, or they tell the bailiffs that, and then here we go, losing people. So, I mean, maybe you don't need everyone, so we'll just get to the 100 and we can excuse from there. That's fine. But we'll seat 70. So 30 people will,
When we stand up and go high, we will have 70 jurors, 5 on each row on both sides.
does that make sense to the clerk's office?
Yes, Your Honor.
So we're going to bring back 100, but we're going to seat 70 questioning jurors. Okay.
If we have a few more, be on standby and just be listening, and the parties can bring up the question.
That's what I was, but,
So they could be there in case of some.
All things we can address that morning. Let's see how it goes.
all right, we'll see how it goes.
Does the court know, or maybe this is a better question for the clerk, my understanding is there's 250 like separate summonses going out to the community,
There's way more than that
or
to get to the
to get to
250. Yeah.
whatever that number is. How do we know, what's different about the ones that are going for our case versus different from another case?
So the way that it works is that the general summons goes out. They are all called down for qualification. They have to still go through the qualification process. And then from the qualifications, if they are not excused through qualifications, meaning they don't meet the statutory requirements, then at that point in time is when they're randomly selected and put into a list to come up.
Understood. That's when it happens. It's not on the summons. Okay.
No. I said that I was going to go down, but I've talked to some other judges that are going to cover me, so I don't have that extra duty. But there are other judges that are going to assist me in qualifying, so I don't have to be downstairs qualifying. But once they get through the qualification process, they're then randomly brought up. Like, so there's a random juror list that's generated at that point in time, and that's how we get the 50. So that's what I was saying. The clerk's office believes that they can bring up more than 50 out of that random selection, but they're summoning morning and afternoon, and they're randomly selecting out of that group that is qualified.
My suggestion is, we can see how the morning goes, and if 50 takes till noon, then we know 50 is the right number. If 50 takes us till 10:30, then maybe we could bring up 70 in the afternoon.
Okay. And that's all depending, like we have a minimum number that we need, and we can always go above. So I agree with that strategy. Is there anything that you want me to add or subtract from phase one about what I intend to do? The introduction of the case is what all I'm going to be doing.
And I'm not requesting this, but perhaps we could include the witness list, since we're introducing everybody. I don't know if that's necessary, I should throw it out there, since we're talking about all the lawyers and your honor and all the staff, but maybe we just also throw in the witness list to see if they...
Okay, I can do that.
Ms. Rodney, they're not able to hear you on Zoom.
And when we go back into the room for the hardships, Your Honor, you're going to control that questioning and then say, do the parties have any further questioning?
Yes.
Thank you, William.
All right, so if you all, I'm not asking that you file the witness list, but if you could communicate it to my office, and I will incorporate it in the opening remarks. Is there anything else in addition to the case introduction? So I'm really just putting this out there because I did it by order, that for the media, it is my contemplation that part of it will be open to everyone and part of it will not be. So if there is, I'm bringing this to the media's attention that I don't necessarily intend to have the media back there with people talking about their hardships, financial or otherwise. But if you all want to intervene, you need to do it by motion. I'm not going to set a separate notice hearing because I've done that in the prior trial order. So from the defense perspective, the state wants the witness list. I'd like to make sure that you share it because there are witnesses that may not be common to both sides.
Yes, Your Honor. I'm also going to put names that they will hear during the course of the trial, even if they're not witnesses. I think that's prudent, given the number of witnesses in the case.
All right, just so communicate,
Yes,
review it.
Mr. Dreiser and I will coordinate that, and it will include both sides' entirety of names that need to be explored with the jurors, potentially.
All right, I'm on to phase two now, which, do you all want me to reread the indictment or no? I don't think that I need to, but I'm asking because it will be days in between.
I don't think you need to.
Does the defense agree?
Yes.
All right. And then, so my phase two, the only portion that I would intend to cover at that point in time is I'm breaking it up significantly from what I normally do. My phase two would look like this, which is you were read the the indictment on whatever day prior. Okay, then I would go into the procedural history that Mr. Fernandez has entered a plea of not guilty and what this means, and then I go through the state has to prove the charges beyond a reasonable doubt. It is now not required, but basically preferential that the trial court read the entire reasonable doubt instruction. Is there any objection to that?
The new reasonable doubt instruction.
Yes, the new one.
No, I was just emphasizing that. No objection.
I was hot off the press. I think I was one of the ones.
You told us about it.
So, yeah. Any problem with me doing that?
No, we usually request it.
Okay, the entire reasonable doubt
Yes, ma'am.
instruction. Is there any other instruction that you want me to give? I generally will tell them that, what my role is, what their potential role is, which is the judges of fact, and that our roles do not overlap with one another, that the attorneys are going to talk to you all and question about, basically I explain that you all are not able to pre-try the case. I give a silly example, generally speaking, that explains what they have done, what you all have done with their questionnaires and formulating some questions. and when I say still example, it doesn't make any sense that I say lawyers are not allowed to pre-try the case, ladies and gentlemen. And so what they have done is they have taken the information. They know all about this case, but they're not allowed to discuss it with you at this point in time. However, they are going to pose questions to you. They're going to require you potentially to weigh your background experiences, things that you have walked into this courtroom with, to determine if you can be a fair and impartial juror. And then I use myself as an example, and I say if I'm juror A or juror B, depending on my thoughts and feelings, my experiences, I may not be able to be fair, and that I should express that. Or I can be fair, because the experiences I can compartmentalize and base it on the facts and the evidence. But I generally do that. Is there any problem with that?
Not from the state, and I don't think that beyond the reasonable doubt, I don't think there's any need for instructions. I think the lawyers can handle it from there.
Okay. Do you agree?
Yes, ma'am.
Okay. So the role of jurors, the procedural posture of the case, and then I will let you all question from there. So I would anticipate my portion, phase 2, to be about 10 minutes long, and then you all would have the majority of the time.
Yes, Your Honor.
Okay. I just generally forecast that for the jurors, because a lot of times they get aggravated or they start asking the lawyers questions like, tell me this, I don't know, and all that stuff. And so I think that has a lot of frustration. The only other one, I can have them reaffirm or re-instruct them on the no communication if you want me to.
I think that's intelligent. And it's also intelligent to remind them that they're still under oath.
Okay. I'm going to have them sworn in again.
Yeah, so I think that, yeah, staying away from the media, disregarding it is always, I'm sure we'll hear that. You'll probably tell them, you're going to hear this 100 times. So
I'm going to remind them of what they've signed, and I can, it's more brief, but I can do that. So the communication rules. All right. Anything else that y'all can think of? Did you all look at the questionnaire,
I did.
Yes.
It looked fun.
the revamped version?
I saw the revamped version.
Was there any addition or deletion that y'all wanted to talk to me about?
The only one that I suggested, which I'm sure the court saw and disregarded, was the other significant employment. I always think that that's interesting.
I didn't disregard it.
I can ask it. It doesn't, it doesn't. There's a lot of questions from the questionnaire that we're going to have to go into more detail on anyway.
Agree.
So I don't think it's not necessary.
I
didn't see this. Did you add the handles, the media handles?
Yes.
So I put it
Okay.
Number 2, I think.
number 3. So it's name, date of birth, social media names and platforms. And then I revamped the residence area, years of residence. The employment, I can add it there if you want, but
It's fine, Your Honor.
I think the how long may prompt you to say, have you done something more? But-
I'll ask it anyway, Your Honor. It's fine.
Okay.
Give me.
I did add prior military law enforcement experience, prior legal education, I should put legal experience. Education or experience, legal education, or I'll put legal experience just to be clear. So this will be duplicated. This is what's going to be required that you all check prior to both sides indicating before they're collected by the clerk and scanned in and sent out to the parties.
You mean check it to make sure all the questions were answered?
Yes, and that there's nothing in addition that needs to be accomplished before we send them away.
Hypothetically, if an answer is illegible, or is
Yes.
the bailiff going to ask that question? Who will ask that question of the juror?
So I don't have any problem. I didn't necessarily think there was any issue that I don't know if you want the bailiffs to do it. What's y'all's preference?
I'm doing it for them. It doesn't matter to me. I'm happy to have the bailiffs do it.
So the question is, if something is illegible, or if it's not filled out correctly, I mean, do you want the,
I thought you had instructed us that we should have one of our own team members go through every single one,
Yes.
make sure that we're satisfied with it.
so what if it's not, there's an issue with it?
Yeah, I assume that you wouldn't want our person like individually speaking
No.
with the jurors, so yeah.
But you both, or you could write the note and the bailiff could, a note could be written saying section 13.
Sure, and then a bailiff would just say, can you make this more legible, or you forgot this one subsection? Sure.
Yeah, I have no problem with the bailiffs interacting with the jurors.
Okay, so we'll have the bailiff do it.
And then we had emailed on the questionnaire about if someone had worked in any of the offices, state attorney's offices or any defense
I
offices.
put,
You can put that in there.
Yeah, I'm sorry, I just didn't print the new one, sorry.
no, it's okay. So this is, I did a slight compromise. I made that suggestion,
I saw the legal experience box.
I thought that would be more general, so that prior military law enforcement experience, prior legal education or legal experience. You don't think that would bring up SAO?
Thinking out loud, maybe dumbing it down to be, instead of experience, working in any law office or something. But that's fine. It's not, I'm overthinking it. It's fine.
Any prior, so what do you want to say?
It's fine as a written, Judge.
So it says any prior legal education or legal experience. And I thought that might even capture people that interned or instead of saying working.
We have people that went to law school that never practiced.
I thought it would cast a wider net than, but again, you all can follow up on any of that, so.
Yeah, spouse.
Do you have a close friend or relative in law enforcement? Do you have a friend, so you want it to say,
In box 10, any prior legal education or experience, maybe you or spouse?
Well,
Any,
if we say spouse, we should just say close friend or relative, because it could be a child or a parent or a sibling.
I just think the more information we have on things that we always want to know, it'll just make jury selection go faster.
And that's fine, we can add.
so I have 15, do you have a close friend or relative who is, I can make that a list, law enforcement officer, what else?
Attorney,
Okay.
victim advocate.
Do you really
I
want?
think keeping it generic is better. I think just mirroring that language. Do you or a close friend or relative have legal experience or legal education? The way that Your Honor's written it, just adding in close friend or relative.
So I'm in 15, I'm in box 15. Do you have a close friend or relative who, and I could put a list if you want, and it says yes or no, and if yes, explain.
And what I think Ms. Stifler was saying, and I may not disagree, is we leave 15 alone.
Right.
But we compromise by adding, going back to box 10, and adding
Close friend or relative.
close friend or relative.
I don't want to do that because I'll add a box under spouse, okay? Because like that's coming where they are. Like all that information is related to them and their employment. I can add a box if you want that under the spouse, it says relationship status, and then it would naturally flow from there. I'm on 11 and 12 where there's a big heading that says relationship status. I can add another box there that says occupation of spouse, and then I could add one there that says law enforcement, close, but then I think I'm duplicating 15.
I would be okay with the compromise of just adding spouse's occupation in box 12 and leaving 15 the same. Then you'll hit it from...
That's what I have, 12. Occupation of spouse, employer.
Presumably that will answer the question if they're employed in law enforcement.
Or if they're
Right.
at an attorney's office.
Right.
That's fine.
I'm going to put spouse or significant other. I'm trying to capture everyone. Do you want to know law enforcement there, or just leave it with 15?
Leave it with 15 is fine.
I'm in agreement with that.
All right. And then the children are covered in 14. Age, sex, occupation. Victim of crime, arrested or accused of a crime. I think I might have you. Okay, 17 is you, the juror personally. 18 is friend or family member accused or arrested of a crime. I think that one was a little bit more significantly different than the one I added some. All right, so anything else related to a questionnaire?
Not from the state, Your Honor.
Not from the defense, Your Honor.
All right, and then I intend to work on a proposed draft of jury instructions. I will get that out to you all. I did see that the defense filed an alibi, which I will include. Is there anything else kind of?
We provided our copy of
Right.
your instructions to defense.
Oh, you did?
Review.
Yes,
So
Your
we
Honor.
can supply that to Your Honor and work off of.
Okay.
We did not include alibi.
I'll forward that.
You do not?
I didn't know you'd filed a notice of intent to claim alibi.
Okay. You know I do the jury instructions, but if you would send them,
I'll send them to court and counsel right now, and then Mr. Dreiser can send the alibi instruction, and Your Honor can at least have those to work off of for the time being.
okay. Anything else that you all, any negotiations that you all want to place on the record?
Your Honor, there's never been a state offer in this case. There has been one defense offer that was rejected by the state.
Okay.
The defense filed a request to take judicial notice. I think there'll be an agreement on that. I just need to provide some information to the state attorney's office.
Okay.
And we filed a motion to eliminate, state filed a motion to eliminate. If you would give us some time on Friday, that would be preferable, and we can knock those out.
This Friday?
Yes, Your Honor.
Okay.
I know you have a hearing in Ms. Gardner's case at 10. We could have time after that, maybe at 11 or 1. We have the afternoon. 1 o'clock?
I have a 1 o'clock now from sentencing. I can give you all 11.
That's fine with the state.
11.
Yes, ma'am?
So, is there anything else that we need to cover? I'm going to talk to your client briefly.
We have some stipulations we'll be filing between the parties. One was regarding BB's testimony, which I've provided to the defense, that we are not calling her as a witness, and a video is going to be stipulated to be admissible. Zoom testimony stipulations, these are things we've previously discussed in front of the court, just officially filing those. A statement of victim identity, I believe the defense will most likely be in agreement with that. And then the defense has filed a motion requesting specific discovery, which I am in the process of fulfilling. And if we don't have satisfaction on that, we can address it with the court Friday during the motions in limine.
Okay.
I say that because their motion asked to be calendared, but I believe we can most likely fulfill what they're asking for, short of a hearing.
Okay. I'll cover the stipulations a little bit later. Have you had an opportunity to talk to Mr. Fernandez about it? I can do it real time with the actual stipulation if you want.
Right. For
You want an answer?
For the Zoom testimony, if they're not in agreement, obviously we have to make alternative arrangements. Now I'm forwarding the jury instructions that the state has prepared to your judicial assistant and CCing defense counsel.
Thank you.
And Ms. Judah with our office, who is very motivated, has been listening, and she prepared a dummy information I sent to defense. And if they approve of it, I'll forward it along as well.
Great, thank you.
And Your Honor, at this time, the state would file stipulation by parties for remote testimony for listed witnesses: Taylor Curtis, Abigail Bridegan, George Cruz, and Vic Quiroz.
Thank you. Okay. All right, Mr. Fernandez, you have been present throughout the final pretrial, and so I've got just some questions that I want to make sure that it hasn't passed you by, okay? This is a very important court date for you in the sense that this is the last, almost the last court date that I'm going to see you prior to your trial starting, okay? And so first, I'm going to start off with, did you understand that the state of Florida is going to abandon 2 of the counts that they initially filed against you?
Yes, Your Honor.
So now you will be facing trial pursuant to the indictment that was filed for count 1, which is murder in the first degree. That is a capital offense, even though the state of Florida has abandoned or withdrawn their notice of death penalty. There are only 2, if the jury finds you guilty of that crime, there are only really, there's one punishment at this point, which is mandatory life in prison. Do you understand that?
Yes, Your Honor.
All right. And then they have abandoned count 2, but are proceeding on count 3, which will be renumbered, and you, for the remainder of this proceedings, will be for solicitation to commit a capital felony. You understand that?
Yes, Your Honor.
So a solicitation is almost like an attempt. So it takes it down 1 degree, 1 level from what they would call a quote-unquote target offense. Do you understand that?
Yes, Your Honor.
So it takes it down from the capital to the first-degree felony. Am I right on that? No, life. It's a life offense.
Yes, Your Honor.
All right. So I'm looking at the MCL number. So it takes it down from the capital offense to a life offense.
Yeah.
Punishable by life, yes. You understand?
Yes, Your Honor.
All right. So it's important,
I think it's a first-degree felony.
on the MCL, it says 3. It's a first degree. It's 1. Okay.
So it's up,
What's the life offense?
that's what I thought it was.
Are you looking at the MCL?
One moment.
No, you're right. First degree felony.
Yes, Your Honor.
Punishable by 30 years.
Up to 30 years, level 9 on the criminal.
Okay. All right, so first degree felony. So to summarize, count 1, capital offense, okay? Count 2 now, formally 3, is a first degree felony, punished by up to 30 years. You understand that?
Yes, Your Honor.
Okay. So it's important that you understand what the state of Florida has charged you with, okay? But by exercising your right to a trial, not entering a plea, what you are doing is you're preserving your not guilty plea. Do you understand that? And you are presumed innocent of these charges, no matter how weighty they are, okay? No matter how many years that they could potentially get because they haven't proven anything in court. Do you understand that?
Yes, Your Honor.
All right, so pre-trial, this case has been going on for some period of time, all right? And it's important for record purposes, and not that you have to, nor are you required to, but if there was any negotiations, that will never come in during the course of a trial because you have preserved your presumption of innocence by exercising your right, but the state of Florida indicated that there was one offer made. Okay, is that true? To resolve the case. Did the defense make an offer or not?
I would not consider it was not formal, it wasn't in writing, it was more of a discussion, and we certainly do not want to discuss it in open court.
All right. Well, from the state's perspective, they thought that there may be some avenue for resolving this case short of trial. Let me put it like that, okay? And they've rejected whatever the discussion was, that they are not interested in it, okay? Is that pretty much your understanding?
Yes, Your Honor.
All right. Now, I've been talking to the lawyers about how this trial will be progressing, kind of giving a preview of what the jury selection would look like. It's going to be conducted due to some of the interest in the case in 2 different phases so that we can get to a good questioning panel, okay? That's where your lawyers are going to be asking the substantive questions of the case, but we're going to handle phase 1, which is hardships and people that think that they may know something about this case. Did you understand that procedure?
Yes, Your Honor.
Okay, and so also by the time that we get to the trial, your lawyers obviously have been working on this case, investigating this case, representing you throughout this entire process, and once the trial starts, there have been stipulations, which are agreements by lawyers, and I want to make sure you've signed this here in open court. I'm going to go over each one that refers to a witness, Taylor Curtis. Is it Jorge? Or is it George? George Cruz, Abigail Bridegan, and Victor, is it Cruz? What is it?
Quiroz.
Cruz. You have certain constitutional rights that this implicates, which is the right to confront witnesses, okay? The way in which confrontation occurs, generally speaking, is in open court, all right? But by the invention of Zoom and the invention of remote technology, it can be utilized during the course of a trial. Have you gone over that with your attorneys?
Yes, Your Honor.
All right, and I am going to tell you that I'm familiar with the law that is required, that is that you, even if you have agreed to this, which I'm going to get to in just a moment, if this goes forward, this is going to be the procedure. I'm going to tell you because it's required by law, okay? Number 1 is that you can see the witness. okay? Very clearly. 2, the fact finder, the jury, can see the witness, okay? Number 3, the witness can see you, all right? And so those 3 parameters at a bare minimum have to be satisfied. So it's as if they are in a courtroom of law. And then what also must be impressed upon, so I will allow this procedure, but it also needs to be impressed upon the witness. The other component of that is that the witness is in a location that impresses upon them that they are in court, that the seriousness of their testimony is impressed upon them, that when they take the oath that they know that they are swearing by penalty of perjury to give appropriate testimony, just like any other witness. So they need to be in a setting that is stationary, stabilized, not noisy, those types of things. So the witness knows, okay, when everyone's seeing, okay, that they know the seriousness for which they are testifying. You understand that?
Yes, Your Honor.
Okay, so I'm sure your lawyers have gone over that with you, haven't they?
Yes, Your Honor.
All right, and have you, and I've seen you sign this in open court, have you had time to consider that?
Yes, Your Honor.
Would you be in agreement with that procedure?
Yes, Your Honor.
Okay. Did anyone threaten you or coerce you to stipulate, along with your lawyers, to this procedure? All right, I'll accept each one of the stipulations as freely and voluntarily entered. There are other stipulations that may come up, but these are the ones I'm going to cover today because it requires planning purposes. All right. Is there anything else from the defense perspective that you want me to discuss with Mr. Fernandez? I think that was it for me.
No, ma'am.
Okay. So just so that you know, this jury selection, we're hopeful that we can be done with it in short order. But I think that you have not been present. The times that we're not necessarily working with the jurors will be time that your lawyers will be working with you, okay, and throughout that process. And just for trial scheduling purposes for the lawyers, I'm going to try the best I can that we are working normal working hours, okay? And I think it helps everyone with the length of this trial and the amount of information that they're going to have to kind of deal with. I'm going to give like full notepads to them. Is there any objection to that?
No, Your Honor.
I'm going to allow them to take notes. I think I shared my preliminary instructions with you. Was there any objection to those? I can resend them if I need to.
I'm sorry, say that again, Your Honor.
The preliminary instructions, I think I explained, I take the standards, but I reorganize them to the way that...
That's fine.
No objection. No.
Okay, was there any objection to the preliminary instructions that I give? It includes notes. It is discretionary whether jurors can ask questions. I was not going to give them that option, unless you all want to be heard about that. Jurors questioning witnesses.
No, Your Honor. No objection to not allowing that instruction.
Okay. So it would just be the preliminary instructions and then the notes instruction, and then it would be given out opening statement.
One moment, Your Honor.
Okay. Do you want me to resend the preliminary instructions? It's different than the standard. No?
That's fine. Thank you, Judge.
I have just a last order of business too. Okay. Did you want to be heard about the questions? Because I wasn't going to let them ask.
No, we do not want to be heard.
I'm sorry?
We do not wish to be heard on that.
Okay, so you're fine with no questions by the jurors?
Yes, Your Honor.
Okay. The last thing that I was going to cover is, was there thought, I've got to file some administrative orders for the clerk's office because there will be interest in this case, and have y'all thought through, I'm going to file the order to keep the names of the jurors confidential. I think I've discussed that with you. Is that also still the party's request, instead of sequestering?
Sure.
Yes?
Yes, Your Honor.
Okay. Then the clerk's office, you all have gotten with them, right, about potential pre-marking exhibits?
I spoke to Mr. Hathaway this morning. I know that the clerk's office has been in touch with both parties. We have conducted an evidence view and exchanged evidence lists. So we have a multitude of exhibits we've agreed are going to come in by stipulation so the clerk's office can pre-mark them.
The last thing I'm going to put as far as evidence is concerned on the party's agenda is that I don't know the nature of your evidence or what it's going to take up in the courtroom, but I would request that if you need additional tables that you get with or places to store, that you all get with the court administration and make sure that those that is available to the parties. The next thing is that there will be requests, and I want to allow for organization purposes. I've got to put in an order related to how the evidence will be communicated once it is admitted into evidence. There will be requests for the clerk's office. Correct me if I'm wrong. I think that's what we discussed, that generally speaking, there's a request to the clerk's office to make the exhibits available.
For the jurors?
No, to the public.
Media.
Have you all thought through that?
Not really.
No, Your Honor.
I need
other
you
than-
to.
Other than we discussed the publication of sensitive photographs during the live stream, but
I need y'all to do that, because what's going to occur is sometimes, like when y'all stipulate, they become the clerk's office and they become public record potentially. So I need you all to make filings about how you want, because I don't know what your evidence is. And so for me to administratively control that and not have to deal with it during the course of the trial, I need you all to research that and figure out what your positions are and file your papers so I can do that.
yes, Your Honor.
Yes, ma'am.
Okay, so you may want to look at some of the cases that were tried that were high publicity cases for the motions that were filed, but my understanding, once you stipulate, once they become clerk to the clerk gets requests to disseminate those things. Okay?
I'll discuss with Mr. Dreiser and Mr. Hill.
All right. So if we can address that, I'll table that for right now.
Yes, Your Honor.
But the jurors, I'm going to go ahead and enter that order because we're not going to sequester until they start deliberating, correct? Is that still the thought?
Yes, Your Honor.
Yes?
Yes? Okay. Okay, I think that was it. You wanted to cover something.
We have access to the courthouse on the weekends because we come in for J1 regularly. I don't know that we have access to a courtroom the weekend prior to either a jury selection or more likely maybe the following weekend. I would envision it would be helpful if we could come and drop off a bunch of boxes and folders and things like that so the day of we're not like schlepping, bankers' boxes in here. So I don't know if there's a way we could contact somebody at security who could maybe buzz us in for our closet or something like that.
Don't you have a conference room?
In the courthouse?
Yes. I think Ms. Janako is giving you all a conference room.
I didn't know if it was going to be just that.
No, that's a jury room.
But they're going to be deliberating on that side, so I didn't know if that was going to be our conference room.
No.
Okay. Well, then, yeah, if we could have access to that.
So you, if you would contact Ms. Janako and she can make arrangements to have you all in here the weekend prior, whenever you want to. You just make an appointment.
Great, thank you.
And then she can coordinate with the bailiffs. And my understanding, I'm not exactly sure where your conference rooms are, but you're going to have conference rooms available to you. So you're not in the courthouse or in the courtroom. You can have someplace private and you can store your boxes there, or I think that would probably be more secure than
Great, thank you.
in the courtroom. But I'll let you if I need to be involved, let me know.
I can email her.
Is there anything else from the state's perspective?
I don't believe so. Can I have one moment, though?
Going to all the states, looking to see if they have anything additional. Did you have an idea of what your daily schedule? I know you said you're going to do basically a full work day. Do you know what that looks like on the start time?
All right, I will be available to the parties at 8:30, but we would start if the parties anticipate any issues, I can always come earlier. But I want to start with actual court proceedings, 9 to 12, and then pick up in the afternoon, 1 to 5. And so the jurors would have a 9 to 5 day, every day. But I'm available starting in August. I generally get to the courthouse anywhere between 7:30 and 7:45 every day. So if y'all needed me earlier, you can always get me.
Great. All right, well, thank you very much. If we don't have anything further, we'll see you Friday.
Mrs. Stifler, did you?
Nothing
Okay.
from the state.
All right, thank you all very much. Court's in recess.
Thank you.